Good morning. We're going to cover a number of the post-grant issues that are under the American Invents Act today. And I'd like to welcome you, all to having gotten here on time. And the first talk will be today on inter-parties review and third-party pre-issuance submissions. And some of the inter-party review aspects or some of the changes have already been implemented. Some parts are going to be implemented at the 1-year date, but the pre-issuance submission is a little different than what we've known in the past and may have some useful aspect for your portfolio. First, I want to talk about some of the strategic considerations that would go on. And we see that, in terms of whether or not you want to have an inter-party review, there's a cost compared to the district court. There's a speed, and that is, of course, a projected speed. There's going to be limited discovery, so there's two sides to this. It's true that you don't get as much discovery, but at the same time, the discovery that you do get is not as disruptive to you. Importantly, you have a technologically sophisticated fact finder, which you're not going to necessarily have in district court. The broadest reasonable interpretation is going to be the rule of the day versus a Markman's construction. And finally, there is, at least theoretically, a lower evidentiary burden. Now, the proposed fees that they've come out with for the inter-parties review are based upon the recovery of the costs as expended, and for a patent challenge that's 20 claims or less, it's going to be about $27,000, and then it's going to increase to about $95,000 for a patent with 60 to 70 claims, and that's quite a bit more than we're used to paying to the U.S. government, but it's still a good deal less than you'd be paying in district court. So it's certainly a consideration if you know you're going to have an issue with a patent. Oh, sorry. Now, under present re-examinations, all of the filings go into the central re-exam unit, and that's made up of examiners. Generally, examiners in the U.S. Patent and Trademark Office are not lawyers. They're not going to understand law in quite the same way. They're technologically, competent, and they have certain amounts of training in some legal issues, but they're definitely not lawyers, except for a very small percentage. Present re-examinations, if any of you have been in any of these, you realize that they're unlimited in duration, that they're really a black hole that your patent goes into, and it can be 3, 4, even longer years in order to get it out. That's great if you are an accused infringer and you want to just, park something that's a problem for you. But if you have a patent, it's a wasting asset that you've got to, address. There is presently an appeal that goes from the, first to the board, and then from the board into the Federal Circuit, and finally, you really can't get any third-party evidence, and that's a problem because if the third party has used a declaration from a non-party, you're not going to be able to collect any information, any discovery, and that individual will not have had the duty of candor. Some of the things that he said can be misleading, and you've got to be able to make an argument that that's the case, an argument that's going to be convincing. Now finally, as those of you who have done inter-parties re-exam know, you can't have interviews with the examiners. And for those of us who do some prosecution, sometimes an interview is the best way to find out what the issues are, what the real concerns are, and then to rectify them. Without any ability to have any interviews, it really can slow down the process. Under the inter-party review, like the current re-examinations, it's going to be based on prior patents and printed publications. The grounds are not only going to, they're only going to be for novelty and obviousness. It's going to be conducted by 3 members of the Patent Trial and Appeals Board, and those members will use the same rules as they use in post-grant review, derivation, and the transitional business method patent review. Appeals go directly from that Patent Trial and Appeal Board to the Federal Circuit, and there's a certain amount of limited discovery. Now, the effective date for this is going to be September 16th, 2012, and it can be instituted after the later of 9 months from the issue of a patent, or 9 months, up to 9 months from the issue of a broadening reissue, or the date of termination of one of those post-grant reviews. Now, any party to the inter-parties review can appeal that to the Federal Circuit, and so it's certainly a way to make your argument, and you're in a much better position with an inter-parties review under the present system and under the proposed system than you would have been under an ex-party review. There's a threshold question to get into these inter-parties reviews. In the old days, it used to be a substantial new question of patentability. And that was at least worked out nominally in the case law that was there. Under the new system and under the present system, it's gone to reasonable likelihood of success, or reasonable likelihood that you're going to be able to show that one claim was invalid. We often refer to that as the reasonable likelihood of success. It went into effect, or the reasonable likelihood of success went into effect when the bill was passed. There's no public guidance right now on what that means, but if you look at the legislative history, it says that the threshold for initiating an inter-parties review is elevated from significant new question, a standard that allowed about 95% of these to go forward, to a standard requiring petitioners to present information showing that the challenges had a likelihood of success in validating at least one claim. There have been a number of inter-party requests, exams that were filed since the changes, and some of those have been rejected. Now, that might suggest that single new question was a lower standard, but it could also simply mean that the PTO is a little skittish on dealing with this new way of looking at it. As a practitioner, I can't imagine that I would have ever filed an inter-parties review or an ex-party review unless I thought there was a reasonable likelihood that at least one of those claims was going to be invalid. And so I don't think it's going to decrease that much from 95%. I think that high rate implies or indicates that most people are not going to bother with one of these unless they think they're going to have some value in it. Now, the petition to get one of these started has to identify the real parties in interest, because there's going to be an estoppel effect. It's got to identify which claims are challenged and the grounds on which the challenge is based, provide a claim construction that shows how that construction is unpatentable based on the grounds that are recited. It's going to identify supporting evidence, provide copies of that evidence, and of course, dealing with a fee-funded agency, it's going to have to provide a fee. Any affidavits or declarations that are going to be necessary to explain those references and explain why there's an inherency issue or anything like that, that had better be in the first position, in the first petition that you're filing if you're trying to get one started. The decision by the Patent and Trademark Office as to whether to institute one of these isn't appealable, so you've got to get it right on the first time, and it's very hard to expand the issues that are involved in one, so you want to make sure that you're pretty complete with it. Now, the patent owner, after one of these is filed, has a right, but they don't have an obligation, but they have a right to file a preliminary statement. And the preliminary statement is not something that's going to have additional evidence and declarations in it regarding why the claim is still patentable. That preliminary statement is going to at most say things such as that the petitioner is statutorily barred and can't file one because of some statutory reason, that the references perhaps are not prior art that are used, that the prior art that has been proposed to invalidate lacks some material limitation, or that it teaches away from the particular invention, or that the claim interpretation is simply unreasonable. It's not going to allow in the preliminary statement to have new testimony, for example, some expert testimony on patentability. Now, within 3 months of receiving that preliminary response, or on the last possible day that a preliminary response could come in, the director of the Patent and Trademark Office, or somebody from the Patent Trial and Appeal Board, one of the clerks, will provide the patent owner and the petitioner an indication of whether that inter partes request is actually instituted. Now, if and after an inter partes review is initiated, the patent owner's response can include affidavits and additional testimony. It can have evidence that's put in. Now, the patent owner can file a motion to amend. They have one by right that they can amend some of the claims. It's possible at a later point that they might be able to amend the claims, but because of the strict timetable, it's not something you can certainly that you'd ever want to depend on. Now, the regulations and the statute permit that sanctions can be imposed for abuse of discovery or an abusive process. You can have protective orders governing the exchange and submission of confidential information. These are not quite as strong of a protective order as you would find in district court, but they can still keep certain information out of the public domain. The patent owner is allowed to move to amend the patent, to cancel any challenge claims, as well as propose a reasonable number of additional claims. And there's a right by either party to move forward with an oral hearing. Interestingly enough, you can actually get some of these stopped. I've been in inter partes re-exams where the two sides decided at some point that they were satisfied with the positions of each other, that they were satisfied with where they were, or they worked out a licensing arrangement. The problem is that you couldn't stop one of these. Once it was started, it was just going to go whether the third-party requester was part of it or not. And naturally, the patent owner has to keep moving forward to try to show that he has something patentable. Under this new inter partes review, you're going to be allowed to terminate, and the board will accept that termination and allow it to be terminated as long as it's not inconsistent with the facts that are part of the record at the time that the board got the request. If there is an agreement to settle and it doesn't go for this board decision, there's not going to be any estoppel effect for the parties. According to the statute and the regulations, the final determination is going to be issued within 1 year after the initiation, and for good cause, the director can extend that by 6 months. There's a problem, I think, with that, and that is what happens after 18 months. Certainly there's a very good argument that after 18 months, there is no statutory authority for the Patent and Trademark Office to be continuing with an inter partes review. Of course, they could switch it over to an ex parte review, but those of us who have dealt with inter partes compared to ex partes realize that once it's in an ex parte review situation, it's perhaps a little easier since the Patent Office is only receiving one side of the story. But at 18 months, there's simply no jurisdiction at the Patent Office to continue one of these. Now, you'll have estoppel in court for any ground that the petitioner could have raised or did raise, arguing that the claim under review is invalid. And there's also going to be an estoppel from inter partes review if the petitioner filed a civil action challenging the validity of a claim of a patent, or if it was filed more than 1 year after the petitioner was served with a complaint for infringing the patent. filed a civil action challenging the validity of the claim, the statute means that that was a position taken by the petitioner, not that was a position in the normal counterclaim that you'd have if you've been in district court. You would normally file in your answer an indication that the patent was invalid. That's not going to be considered as raising the estoppel effect. Now, if the petitioner filed a district court action after requesting the inter partes review, the district court action is stayed, and if the estoppel is instituted, it's going to apply at the U.S. Patent and Trademark Office, in district court, as well as in the ITC. Now, it's still unclear, even after many years of having similar language, what the idea of could have raised means, what the scope of it is. But you know, it's certainly a situation that if you have a number of references and you don't provide them all that are non-cumulative, you're probably going to have a problem with applying them if you ever find yourself in district court. In terms of discovery, it's going to include depositions of witnesses submitting affidavits or declarations, and also what is otherwise necessary in the interest of justice. Now, you're going to have a good faith explanation of why that evidence actually is thought to exist if the PTO takes the position that it has in interferences, and the discovery is likely very limited because of the limited amount of time that's provided for one of these. The regulations that are proposed right now suggest that this is going to be a very strictly phased discovery or sequence discovery, with each party providing their respective discovery periods as it moves through that first year. There will be routine discovery, such as production of any exhibits that were cited or testimony, cross-examination of the declarants or affiants that were used, as well as any information that is inconsistent with a position that's being advanced by the party in the proceeding. And as you all know, that's perhaps the most difficult to address, since there are often statements made that are discoverable at some later point that would suggest that you have not provided all information, and so that might be the most difficult thing to satisfy at present. There will be allowed to have motions for additional discovery. You'll be able to compel testimony, and also you'll be able to have live testimony if it's necessary. Now, presently, inter partes re-exams or inter partes review is limited to patents and applications filed on or after November 29, 1999. The interesting thing about the new inter partes review is that it's going to be available to all patents 9 months after grant termination of a post-grant review or within 1 year of being sued. And this allows a lot of patents that formerly were perhaps too broad or not likely to be valid to be challenged, but you know, because of that limitation, that time limitation, in the past they were never challenged. This next slide has a chart showing the differences between ex parte re-exams, inter partes re-exams that were available previously, and then post-grant review as well as inter partes review. And it just shows, you know, who's doing the examination and whether or not you can remain anonymous in your requests, and whether or not you are going to have a lawyer who's a fact finder or simply an examiner. Now I'd like to switch gears a little bit to talk about third-party submissions of prior art before grant. And this allows third parties to submit patents and printed publications of potentially relevance to examination if they meet certain requirements. First, you have to provide a written explanation of the relevance of the submitted document. You have to pay the associated fees, as you'd expect for a user-funded agency. and you must include a statement affirming compliance with the particular statutory section that allows you to submit these. In some respects, these submissions are similar to the current protest practice that you find in what we call the Manual of Patent Examination Proceeding, section 1900, and that's for protests about a particular patent. However, those protests had two problems with them. The first was that you had to file the protest before the application was published, which seems like it'd be very difficult to do unless you knew what your competitors were doing, and also that you could say nothing about what that submission was. It doesn't, you also had to provide service on the other party. This new pre-grant submission, you don't have to serve the other side. The Patent and Trademark Office will do that. And interestingly enough, you're allowed to provide an explanation. Now, the effective date is September 16, 2012, next September, but it's going to be for any application filed before, on, or after that particular date. So it opens up the possibility that you can use these for any type of application that's presently there. According to the regulations, an examiner will consider the documents and concise description submitted in the same manner that the examiner considers information and concise explanations that are provided in an IDS. Well, those of you who have been in the business for a while realize that usually when we do an IDS, we don't give a submission of an explanation. That went out about 15 to 20 years ago, and people usually don't do that now because they don't want to be charged with misleading the examiner. So the question of how the examiner will look at these is a real question you have to appreciate. According to the regulations, it's best practice that each concise description point out exactly where that examiner should look, and the third party may present a concise description in a format that would best explain to the examiner the relevance, such as a narrative description or a claim chart. Now, in the past, I certainly would not have made any suggestion that you should provide these kind of submissions to the Patent Office. And the reason is that I believe that a good advocate could do a much better job with a reference in district court, even with the higher burden, even with the ability that you're going to have to convince a non-technical person of your case. So I would have recommended you just keep these in your pocket until you find yourself in district court. I think that this submission is a little bit different, and the reason it's a little bit different is you're allowed to explain to the examiner why this particular reference has an effect or why this particular reference invalidates the claim. The beauty of that is that in the Patent and Trademark Office, the examiner considers the broadest reasonable interpretation. Well, the broadest reasonable interpretation is something that the examiner can see, but often you can explain why the interpretation could be even broader. So when you're submitting these, if you can explain not only how this applies, but get the examiner's attention so the examiner understands, gee, this could be interpreted very broadly, that's going to either force the other side to come in and say, oh no, it's not that broad, which is going to be helpful for you if you're the patent holder, if you're going to be accused of infringement at a later point, but it also helps to set the stage for what the examiner is going to be reviewing. So in this case, there might be some value to submitting this just to tell the examiner how broad you believe or that you fear this might be. Now, no fee is presently going to be required if a party submits 3 or fewer total documents when the submitting party indicates that the submission is the first particular submission and indicates that they presently don't plan on making any other submissions. If you have more than 3 or want to supply more than 3, then it's going to be a reasonably low amount of money. It's going to be $180 for 1 to 10 proposed for 1 to 10 documents, $360 for 11 to 20 documents. So for a limited number of documents or less than, or 3 or less, it's going to be, you know, a very small cost. You can also provide affidavits or declarations to show what the date of this would be. In some cases, you might have a something from the internet. You might have something that is not really dated, and if you can, it might nevertheless be a printed publication. You may need to have some declaration to show exactly when this was published. And according to the regulations, there's also no requirement that this simply be prior art. In some cases, it's possible after the date to show that as of the date of filing, this could not have been enabled. There's a well-known case in the Federal Circuit, from the Federal Circuit, in Ray Goodman, and it dealt with an individual who was trying to get a patent on plant GMO, and you know, the claim was to dicots and monocots, and several years after the filing date, there was a publication that said that they had not been able to make this particular technology work for monocots, and as a result, the Federal Circuit said it wasn't enabled as of the filing date. So you can often raise issues that would perhaps invalidate the breadth of the claims or some part of the claims if you can provide evidence that something wasn't enabled, as well as that somebody had done something in the prior art that you know, would preclude patentability. Now, according to the new statute, these submissions have to be made before the earlier of date of the notice of allowance, or 6 months after the later of 6 months after the date of the application when it's first published, or the date of the first rejection of any claim in the application. So what that means is you've got to be monitoring to make sure that when something's published, if there's a claim in there that you're concerned about, you have to be very quick on getting it to the patent office. Otherwise, you're going to lose this window of opportunity, and you know, the Patent and Trademark Office can't necessarily take these things if it's not statutorily provided. Now, there's for that reason still a problem with getting this in while it can do some benefit to your client. And from the standpoint of inter-parties review, many of the things that have been said about inter-parties re-exam are certainly likely to be still true with that. In that respect, I mean that, you know, they take a very hard look on patentability. With this new ability to provide pre-grant submissions, I think it's at least worth looking into, because you've got the ability to not only get this art in front of the examiner, but also help to give the examiner understanding of what the broadest reasonable interpretation is. Any questions? And if not, we'll go on to the next presentations.
I've got a question.
Yes?
Is it possible to file these third-party observations anonymously or by a straw man?
Yes, yes, you can provide that. You don't have to even serve the other party. In other words, if the patent office accepts it, and they'll accept it if it's in that window, then you don't have to even make sure the other side gets it. The patent office will make sure they get it. You can do this anonymously. There is a very strict timeline, and that timeline is what I've described, and it's got to be received as of that date. Normally, we're in the habit of using a certificate of mailing. You know, I mailed this on the 22nd, and I don't care, Mr. Patent Office, whether you get it on the 24th, because I mailed it on the 22nd. No, that's not going to be permitted. It's got to be received in the office before these particular dates. There was another question? Yes?
Yeah, just to expand on that, what do you really mean by anonymous? Because Anonymous means one thing in the English language, but how can they guarantee you'll be anonymous if you
I would say that if I was going to be anonymous, I would go to a law firm, perhaps one I don't normally use, and I'd say, I'd like you to submit this. I'd like you to say these things in your submission, and because of the attorney-client privilege, you know, I don't want you to disclose that I'm your client. You know, you don't have to worry, there's no estoppel issue. Because there's no estoppel issue, you are in a situation that this is never going to come out. Now, in a later litigation, there could be discovery issues, and it might come out, but it shouldn't, because this is attorney-client privileged, that you've done this. And so I think you can, you know, I wouldn't say hide behind, but you can certainly keep it from the general public that you have done this, and that you know, you were pointing this particular thing out. Yes?
Two questions. First one, will this be put into the official file so everyone can see it in the file wrapper? First question.
If it is accepted, in other words, if you've met those strict guidelines, yes, it's going to be part of the file. If it does not meet those strict guidelines, it's certainly not promised that it's going to be there. I think a lot of examiners would put the reference in there. They might not bother with putting the concise explanation, but that's, you know, something that, yeah, it'll be part of the file if you get it in within those dates. Anything else?
Yeah. Oh. Second question, is there any downside in terms of higher level of presumption of validity or things like that? I understand there is no estoppel, but is there any other downside?
You know, usually when I'm in district court, I worry about making an argument on a reference that I say invalidates a claim. If that reference was something that the examiner saw. As you all know, on the IDS, it says, there's a checkbox, and it says this reference was considered. Well, one was considered, even the MPEP says doesn't mean read. So I don't know what was considered means, but I'll tell you, a jury, when the other side says, you know, the government attorney who doesn't have a dog in this fight, you know, was looking at this, and this government attorney, you know, he's trained in this technology, does this every day, he considered this, and now they want you to believe that this invalidates it when the examiner, the expert, didn't. You know, that has very strong appeal to a jury and strong appeal to a judge. So, yeah, there's no estoppel effect, but does it have a higher standard? No, it's not a higher standard, but it has a psychological standard that's an issue.
Other question?
Yes.
Go ahead. I wanted to raise that 35 U.S.C. 325D, the last sentence, makes it fairly clear that prior art or arguments previously presented to the office are taken into account in deciding whether to institute an ex-parte re-exam, an inter-parte re-exam review, or a post-grant review. So there's a slight downside that arguments that are presented in these third-party submissions would be considered in whether to institute one of the reviews.
Yes, I'm not so sure you'd want to go back to the well if you hadn't been able to convince him in the first place, but yeah, absolutely, that's going to have an effect.
And it's actually a little bit broader. The 325D language is that substantially the same prior art or substantially the same arguments were previously presented. So there is some downside risk.
Yes.
In the subsequent proceedings.
In the same vein, the kinds of references that one would submit as a third party, there's no requirement that they be completely new references in the record, right? They may be something that could have been previously shown up in the record, either found by the examiner in a search, or maybe even submitted as part of an IDS by the applicant. Can you submit a reference like that and go, I think this really is a killer reference, and the examiner didn't catch it, and the applicant submitted it together with 100 other references where it didn't exactly stick out, so you kind of resubmit a reference for the
With
record,
an explanation
observation.
of, you know, your view of what the broadest reasonable interpretation and how it's used. You're right,
Could.
but when you're facing something where the individual has put in a banker's box of documents, this is a chance that you're going to be able to put it in, but as Judge Clark has said, the examiner is going to, you know, look at this, and if you've already shot this particular shell, you might not have a chance to shoot it again. In district court, I mean, if you had already made that argument and the examiner had already rejected it, it's not going to be quite as powerful as if you know, brought it up fresh.